So why don't all people know about the police ambush in the context of a peace model of interviewing suspects? For many people, they think a police interview of a suspect is like what they see in the movies. Police questions asked in an aggressive manner, the interviewing officer shouting at the suspect, "We have the evidence," and then slapping it down on the interview table and saying, "Look at the photos, read the witness statements, check the fingerprints we found, check the mobile phone messages, just confess and we can all go home." And maybe that might be the case in some police interviews. But in my experience, the vast majority of police interviews are not conducted in such an overt confrontational manner. Passive aggressive officers, yes. Overt aggression, no. Instead, across the UK, police interviews are guided by the peace model of interviewing suspects, which is intended to ensure ethical and fair interviewing practices. PEACE stands for P for preparation and planning, E for engage and explain, A for account, clarification and challenge, C for closure, and E for evaluation. While this framework aims to safeguard fairness, it is important for you to be aware that the peace interviewing process can sometimes be used strategically to ambush suspects. This is especially true during the challenge phase, where previously undisclosed evidence, for example, CCTV footage, witness statements, physical evidence like fingerprints, mobile phone evidence like messages, is only disclosed and introduced into the police interview after the suspect has been given an ample opportunity to provide their account, and they did. And no doubt it will come as a complete surprise and shock to the suspect and their lawyer that the police knew all along the suspect's conduct and, to some extent, their mindset too. This tactic can lead the guilty suspect to regret talking openly in the account stage, only to realize the police had evidence all along. But it can also mean that for innocent suspects who are so open about their accounts, so desperate to prove their innocence, that they can inadvertently contradict themselves and the evidence, or make admissions which they may later regret after being shown the evidence the police had in their file, but waited for them to dig a grave with their name on it. This is why, if you are a suspect, you must treat very carefully in a police interview, particularly in that account stage of the police interview, when giving your version of events, as inconsistencies and contradictions with the evidence later disclosed could strengthen the case against you. So in this video, I will not only explain how the peace model of interviewing suspects works for the police, but also share why, if you are a suspect or a lawyer, you need to be wary of this interview strategy. I will explore the risks of talking, particularly during the account phase, and provide practical general advice how you can avoid making statements that could seriously harm you and your credibility. And as a defense lawyer, I have done hundreds, if not thousands, of police interviews over the 3 decades. And here I'm on this channel and I'm sharing my insights. And if you find this content useful and interesting, then please subscribe. Let me first break down the peace model of interviewing suspects down step by step and explain how and where the police ambush can and does take place in the police interview. 1. P is for preparation and planning. Police officers spend a significant time preparing before a police interview, especially in very serious cases, including the ones I've been involved in. This is where they build a detailed strategy, reviewing evidence they have obtained, identifying gaps, and tailoring their approach to the suspect being interviewed. Key tasks for the police during this stage include analysing available evidence, e.g. CCTV footage, witness statements, forensic data, thinking about preparing open-ended questions, thinking about preparing targeted questions to address gaps in the evidence, e.g. proving guilty intent, thinking and preparing questions about the evidence gathered to identify inconsistencies and contradictions if an account is given, and considering the interviewee's personal circumstances, such as age, mental health, or cultural factors. In short, the police enter the interview process with a clear goal in mind. It may be to fill a gap in their evidence, but it also may be to elicit admissions, confessions that satisfy the legal requirements of an offence under investigation. And remember, an offence can be broken down into the actus reus, or guilty conduct of an offence, and the mens rea, the state of mind behind the guilty conduct, and to disprove any defence put forward. The police will need evidence of both guilty act and guilty mind to secure a charge and conviction. So, for example, in a case of criminal damage, questions might focus on whether the damage was intentional or recklessly caused or accidental. If the police can draw out responses that suggest anger and planning, they can demonstrate intent rather than it being caused accidentally. In a theft investigation, for example, the police might probe for answers about behavior and motivations. For example, why did you pick up the item? What were you thinking of at the time? Why did you leave the store without paying? And how much money did you have on you when you entered the store? These questions, if answered by the suspect, are to assess whether the suspect was dishonest and had the intention to permanently deprive the store of the item, or whether they simply forgot to pay for it. The police may design and structure questions to elicit responses around these types of questions from the suspect that closes gaps in their evidence, especially on the issue of trying to establish the suspect's guilty state of mind. So what does this mean for the suspect? Well, the suspect and their lawyer must recognize lines of questionings like this and avoid volunteering unnecessary detail that could help the police meet their evidential burden. 2. E is for engage and explain. This stage sets the tone for the entire police interview. In this phase, the police will attempt to establish a rapport and explain the purpose of the interview and may come across as very helpful, informing you of your rights, including your right to legal advice. They'll make statements like, you have the right to legal advice. This interview will be recorded for accuracy. They are also required to clarify your rights, which is underpinned by the 3-part police caution. Part 1, you do not have to say anything. Part 2, but it may harm your defence if you do not mention when questioned something which you later rely on in court. And Part 3, anything you do say may be given in evidence. The police will explain the caution to you and break it down into those 3 parts. Part 1, your right to remain silent. Part 2, but silence and saying no comment when questioned may harm your defence. This is because an adverse inference may be drawn from silence if it was reasonable to have mentioned a fact at the police station. And an adverse inference could mean the court considers that a defence that is put forward at the trial but was not given at the police station is a recent fabrication. And more said about this later. And Part 3, anything you do say may be used as evidence as the interview is recorded. While this stage may seem straightforward, it is important to remember that the police are setting the stage for the interview to make you feel at ease, to encourage openness, especially by explaining this as an opportunity for you to tell us what happened, tell your side of the story, and how your silence may harm your defence and look bad if the case gets to court. And I've done separate posts on the meaning of the police caution and whether it is a sign of guilt, so please watch these videos too. But the main point is, don't be lulled into a false sense of security with the police being friendly. While transparency is underpinned by a non-confrontational police approach, which is central to that police model of interviewing strategy, the police interview is still a formal investigation and you are the suspect. At this stage, if you haven't already done so, always consult with your solicitor before saying anything substantive, including to confirm whether you understand the caution. 3. A is for account, clarification and challenge. This stage is at the heart of the police model and the part where you must exercise the most caution. It is in fact separated into 3 phases: the account phase, the clarification phase and the challenge phase. Phase 1. During the account phase, you will be invited to provide your account. The officer will ask you to give your version of events without interruption. This is where open-ended questions are used by the police officers to encourage you to talk freely. And the officer will actively be listening with nods of the head, allowing you to search your memory, and will be making notes. Examples of open-ended police questions which the police might ask include: can you tell me what happened in your own words? Can you walk me through what happened that day from midday onwards? How did you get involved in this situation? And can you explain what happened next? This can feel like the most straightforward part of the interview process, but it is often where suspects risk making mistakes, being too open, desperate to prove your innocence, guessing time, generalizing what you were doing. Be wary of how you phrase your responses, especially if you're trying to recall your movements and timings, but you don't know the exact details. The police may use your own words later to establish inconsistencies with that evidence that they haven't yet disclosed to you. So, if you are unsure about specific details, it is better to state that clearly than to guess or speculate, especially over timings, if you are talking. But remember, at this stage, the police may still be holding back key evidence that they plan to present later during the challenge phase. Next comes the clarification phase. After listening to your account, the officers move to the clarification phase and will seek to clarify details not yet provided by you. Can you elaborate on what you meant by seeing someone suspicious? You mentioned meeting someone. Who was that? What time did you meet your friend? And then the police will cleverly move to close-ended questions, which elicit responses of yes or no, correct or incorrect, to pin your account down. They might ask targeted closed-ended questions like, you said you were at home, is that correct? You said that he hit you first, right? And you returned home at 8 p.m, is that correct? You can see by these questions that you can only answer them by yes, no, correct or incorrect. Next comes the challenge phase. The challenge phase is where the ambush element of the peace model of interviewing suspects comes into play. As explained, while the peace model is designed to promote fairness, it is not uncommon for the police to present previously undisclosed evidence to you and your solicitor at this stage in the police interview. This strategy is often justified so as to obtain an account which is not tailored to fit the evidence the police have gathered. That is understandable in many cases, but less so when a suspect is being asked to account for their movements or money transfers or exchange of messages some time ago. This previously undisclosed evidence could include CCTV footage showing actions which might be used to contradict an answer previously given in the account phase if you said you were not present at the scene. Witness statements that provide alternative narratives to one that you gave, for example, saying that you punched first. Physical evidence that undermines your explanation, for example, phone evidence to confirm your phone location in an area that you said you were not present. Bank records of income and savings not previously mentioned in response to police questions about what are your income and what are your savings. This tactic can catch suspects off guard, leading to hasty explanations, contradictions, or admissions. So how do you protect yourself in a police interview from saying something which is inconsistent with the evidence? This can be challenging, but 3 are mentioned if you are answering questions and putting forward a defense. And I hasten to add that these 3 strategies are by no means perfect strategies to avoid an adverse inference or to maintain your credibility. 1. Avoid making definitive statements too early in the police interview. If you are unsure, admittedly, this means that you might come across as evasive and vague. 2. Consult with your solicitor before responding to new evidence and stop the interview asking for legal advice. Again, it doesn't look good to ask for the interview to be stopped, but at least it can help you understand the significance of this evidence and be given legal advice to guide you whether to continue to answer police questions or to say no comment. And the 3rd strategy, a carefully drafted pre-prepared statement which provides an outline of your defense in anticipation of evidence which might be disclosed in the police interview. This statement can be handed in or kept backed by your lawyer. The statement is signed and dated and timed to reduce the risk of an adverse inference. Again, it's not perfect, but at least it provides a pillar for your defense if the case goes to trial. And the alternative strategy is to give no comment interview or to remain silent, especially when dealing with officers who have provided limited or no disclosure of the evidence prior to the police interview and who are being cagey. Mr. Feasy, I'm not willing to disclose this to you. Would be a signal to me to say my client needs to give a no comment interview. The no comment interview will avoid any possibility of contradicting evidence not disclosed prior to the police interview, but is during the police interview. But a no comment interview, a silent interview, also risks an adverse inference being drawn by your silence to the police questions during the police interview. 4, C is for closure. Closure is about wrapping up the police interview in a way that leaves no loose ends for the police. Before the interview ends, the police officer will summarize what you've said and give you a chance to add or clarify anything. This is also an opportunity to ask questions or raise concerns. 5, E is for evaluation. After the interview, the police will assess the information obtained and decide how to proceed. The evaluation is based on whether the evidence collected, including in the police interview, supports charging the suspect for the offence being investigated, whether your responses strengthen or weaken the police case against you. Every statement, every comment, every nod of the head you made during the police interview will be scrutinised by the police officers, and the police will be well aware that any inconsistencies, any contradictions, any admissions can be used to support a prosecution. So just some final thoughts about the PEACE model. While the PEACE model is designed to ensure ethical and transparent interviewing practices, it can also be used as a powerful tool for building a case against you. The ambush of evidence during the challenge phase is a particular common tactic that can lead to an unintentional self-incrimination, admissions, inconsistent accounts given, all of which can undermine any potential defense, leaving your credibility in complete tatters. To protect yourself, remember, don't think of a police interview as a friendly chat with friends from a local pub. The police are doing a job. If they want to, they can be very helpful to avoid you being charged. But if they are being unhelpful, they will keep evidence away from you and your lawyer until the end of that police interview during the challenge phase. Always consult your solicitor before the interview and during breaks. Be cautious about volunteering information that the police do not specifically request. Avoid speculation or assumptions about what the police know. Think carefully whether answering questions or staying silent or no comment interview is the best strategy. Don't forget to consider a controlled statement and a no comment interview as a strategy. By understanding the PEACE model of interviewing and preparing accordingly, you and your lawyer can navigate the police interview process without inadvertently harming your defense and case. I hope you found this video interesting and insightful. Feel free to comment as always, follow and subscribe for more.